Hey everybody, Matt Johnston here, Matt the Lawyer. We're talking about the Supreme Court and the Fair Labor Standards Act. So, we're going to be talking a little nerdy employment law stuff here, but it does make some applicability to people who pay their employees based on either a day rate or an hourly rate and have job duties that would be classified as exempt. So before we get started, just a quick sort of sorry about the strange little lights. This is what happens when you have a bright sunny day here in Frederick, Maryland, here in the middle of February, and it's 75 some odd degrees outside. So, hey, there you go. Anyway, yesterday on February 22nd, the Supreme Court handed down its decision in Helix Energy versus Hewitt. Helix Energy is an oil producing firm. They have a number of oil rigs in the Gulf of Mexico, and Mr. Hewitt was employed on one of those rigs. Now, Mr. Hewitt was a tool pusher. I had no idea what that meant until I looked it up. Apparently, it's kind of like the boss, the foreman, something like that. And he had duties, job duties that were in part exempt job duties. Now, oil rig workers will go out for 28 days typically and back for 28 days, and they'll work 7 days a week. So, Mr. Hewitt's pay was computed on a day rate, which is pretty common in the industry. So, Mr. Hewitt was guaranteed a certain level of pay each day that he worked. So, he was guaranteed about $983 per day, which is good pay if you can get it, but he's also working 12 and 14-hour days, so, take it for what it is. But Mr. Hewitt was arguing that he should be entitled to overtime pay because he was paid on a day rate and not a guaranteed salary. So let's step back a little bit and talk a little bit about the exempt employee rules. So the Fair Labor Standards Act starts with the notion that every employee is entitled to overtime and minimum wage protections, and they are confusingly referred to as non-exempt employees. Exempt employees are therefore exempt from overtime and minimum wage laws. In order to qualify as an exempt employee, particularly in these circumstances that we're talking about here, you have to qualify under one of the exceptions. Now, there is an exception for executive, managerial, and administrative employees, and I've talked about that in a number of different forms. But essentially, to qualify, you have to be paid a fixed weekly salary that does not vary based upon the amount of days worked. And that's an important distinction, according to the Supreme Court, that it is a weekly salary. Even though Mr. Hewitt was guaranteed to get whatever $983 times 7 is each week, and he was paid twice a week, his pay was calculated on a daily basis, not paid on a weekly basis. So because he was calculated on a daily basis, and let's assume he was working 12 hours a day, in a 7-day week that he's working, that is 84 hours, for which he would then be guaranteed 44 hours of overtime. And if he's making $983 a day, his overtime is going to be pretty steep. So, what the Supreme Court has said is that if you are going to pay somebody on a salary, their salary basis, their pay basis, has to be based on the week, the work week. Now, there is some very narrow exceptions or an alternative to get there. But for most clients, most small businesses out there, if you have an employee who otherwise qualifies, you need to make sure you're paying them on a weekly salary basis, and their pay is not computed based upon 40 times some hourly rate. So there's a lot of employers out there. It's like, well, I have an employee, I pay them 25 hours a week, $25 an hour. They work 40 hours a week every week. They're salaried and things like that. No, I'm sorry. Under this ruling, that doesn't count. So if you have somebody who's making $25 an hour, 40 hours, their salary they should be paid $1,000 per week, regardless of the number of days that they work. Okay, as opposed to saying, well, I pay them $25 an hour, but they always work 40 or more hours in a week. So you need to go back and make sure that somebody's salary level is based upon what you want to be paying them, and that their salary is computed not by multiplying an hourly or a day rate, but by just saying their salary is $1,000 a week, or whatever the number is. Now, just a reminder, if you are trying to figure out what you need to do for a salary level, the salary level must be at least $684 per week. That's pre-tax, and cannot vary based upon the number of days that the employee is working. So the salary does not change based upon the quantity or quality of work. So if you are unsure of how your pay structures are set up with your middle managers or somebody along those lines, this is a good time to review this. The Supreme Court, while it got into the weeds of some regulations and some statutory provisions, it basically boils down to this. If you have a salaried employee, they have to get a guaranteed weekly salary. And it cannot be based upon the number of days or hours that they work. It has to be a flat weekly salary. In the meantime, if you have any questions about Fair Labor Standard Act, please give us a call. We can certainly take a look at what your current pay structures are and have a chat about how to best improve them. In the meantime, be careful out there. I'll talk to you soon. Go out and watch some live soccer. Bye-bye.